questioning or interview that Sergeant Mokhane conducted with a suspect.
Yes.
Yeah. And
in the boardroom.
Yes, in the boardroom. In other words, we're not busy with the taking of a warning statement, but just merely an interview, an informal interview that a police officer had with his suspect.
Is that the background to the issue?
Indeed, ma'am.
Yes, Ms. Mshololo, let me understand you. What are we dealing with?
My Lord, we are dealing with the interview which took place between the suspect and the witness at the boardroom.
Right.
Where,
it's an interview.
It's an interview.
Yeah, what about it?
Yes. Then, my Lord, my submission is that because the witness said he explained the rights, he explained the allegations, and the accused responded. Therefore, that interview ought to have been recorded.
Right?
Yes, my Lord. That's
if it's not recorded?
It's my submission, my Lord. The court can make a ruling.
Yeah, fine. Is that what you are dealing with, and is that what your colleague is dealing with?
That's what.
Now, how does this form come into play?
My Lord.
This form, which you say the court must peruse.
It's because, my Lord, this form says statement regarding interview with the suspect. Hence, I referred this witness to that form. And it says, my Lord, on the first page, statement regarding interview with suspect, paragraph 1, my Lord.
Now we are reading paragraph 1 where it says the form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on a folio attached to the folio of that page. And folios must be signed by the suspect, the interpreter. So you are saying this form is applicable, in other words?
My Lord, that's my respectful submission.
Okay, you want me to rule on that?
So to say, during that interview,
it must be signed. The form must be signed according to you.
It must be recorded, my Lord.
Yeah.
Although, my Lord, I am not saying that the witness was bound to use this as it.
No. Let's have. The submission is that it must be filled, this form, or what is your submission?
Yes, it must be.
It must be filled.
My Lord, can I just refer this honorable court to just one judgment?
Which one is
I'll
that?
be quick. I'll be quick, my Lord. I won't waste the court's time.
Which judgment is that?
It's the Henry Foster and the Minister of Safety and Security. It's judgment by.
Others.
Yes.
I've read this judgment.
Yes.
It's about damages.
Yes.
Unlawful arrest and the assault of a suspect who subsequently. Obviously, the charges were withdrawn because there was not sufficient evidence.
Yes, but there is a principle that I want to bring it to the attention of this court.
Okay, fine. Bring it to which principle is that?
Thank you, my Lord. On page 23, paragraph 28.
Wait, I'm going there.
Yes.
Page. Wait.
Page 23.
Wait. Page 23.
Yes. Page 23. It's paragraph 28, my Lord.
Paragraph 28.
Yes.
Yes, put it on record.
Yes, my Lord. Paragraph 28, under warning statements, my Lord. It says, express provision is made in every warning statement in this court's jurisdiction for the completion of a warning statement each and every time that a suspect is interviewed. Paragraph 29, the constitutional protection provided for in terms of Section 35 of the Constitution to arrestees is embodied in this principle. There is no justification for any interview with a suspect who has been arrested or called in for questioning to take place without a warning statement being completed. Paragraph 30, my Lord. The very term warning statement indicates that the person is a suspect and has been warned of his rights, and in particular his rights to remain silent before any such interview may take place. Paragraph 31, it serves no purpose to attempt to recognize that an arrestee is not obliged to say anything, make any admissions, or answer any questions unless he is specifically forewarned of these rights and signs in the warning statement that he has been so forewarned prior to any interview or interrogation taking place. My Lord, I will skip all these paragraphs and then just go to paragraph 33. Oh, sorry, my Lord, I have not finished. Yeah, I'll skip this. And then paragraph 34, my Lord, the next page, on page 24, which says, it was startling to hear that both defendants' witnesses, who were experienced policemen, believed that they were entitled to question a suspect or arrestee at any time that they wish to do so without being compelled to complete a warning statement. And the last reference, my Lord, is just one paragraph before it goes to, I'll summarize it, my Lord, paragraph 38.2. Paragraph 38.2, I'll be quick, my Lord, wherein it refers to the warning statement which is headed, statement regarding interview with suspect. Paragraph 38.2, my Lord. 38.2.
Yeah.
Yes, my Lord. It says, the warning statement which is headed, statement regarding interview with suspect. It is referred to as SAP S3M document and embodies 12 pages on the cover and on every first page under the insignia of the South African Police Statement. The statement regarding interview with the suspect. This form must be completed every time a suspect is questioned, irrespective of whether the suspect is in detention after an arrest or not. Where any space provided on the form is insufficient, continue on the portfolio and attach the portfolio to that page. Folios must be signed by the suspect, interpreter, deponent, and commissioner of oaths. Thereafter, my Lord, on the same paragraph, the interviewing police officer is required to record that he has informed the suspect of the allegations, that he is investigating against him, her or her, to ensure that he understands the allegations. There are numerous introductory paragraphs and forms that require completion. The suspect is entitled to make, or if he wishes to do so, whereafter both suspects and the member of the SAPS are required to sign the document. All of the constitutional safeguards provided for in respect of arrest, accused, and detained person are contained herein, and the document sets out each and every step that must be followed in completion thereof. Paragraph, this is the second last paragraph I'm referring this court to, my Lord. There is no basis in law on paragraph 19, my Lord. Paragraph 39. Yes, paragraph 39. There is no basis in law of fact to conduct any type of an interview or interrogation without completing such a document. Any attempt to do so will render the arrest and detention of the suspect not only unconstitutional but unlawful. I am fortified in my view that the arrest and subsequent detention of the plaintiff in this matter was not, this is for the judgment of this case, my Lord. But can I just read it to complete the paragraph? The matter was not only unconstitutional but unlawfully because the defendant's witnesses testified under oath that they were of the view that they were entitled to interview and interrogate the plaintiff without having completed such a document. This can never be the case. The express term of the document make it abundantly clear that when a suspect signs them, he or she does so in order to acknowledge that he has been notified of his or her rights and he understands them. Paragraph 40, the practice whereby these documents are completed merely satisfies the prosecutor that the suspect may now be taken to court is to be frowned upon and not condoned by this court.
And it's a single judge. It's a single judge who says that.
Yeah.
Oh, it is.
Yes, ma'am. It seems that notice in terms of the Constitution is completed before the person is accepted into the cells, but merely as formality and for no other purpose. The warning statement is also completed merely as a formality that is required for administrative purposes or as part of the paperwork, but not for the intended purposes. As previously stated, mere lip service is paid to the rights embodied in the Constitution as detailed in the documents. They are significant in determining whether an arrest or subsequent detention are lawful or not, can never be overemphasized. My submission, my lord, to this court is that this form, it does not, my lord, necessarily say it must be completed when the suspect is charged. But this form says, as I've read it into the record, it must be completed whenever there is an interview between
Who must complete it?
It must be completed by the person interviewing the suspect.
By the police person?
By the police person, yes, my lord. Interviewing the suspect. If I can go further, it even says the number of the people who were present during the interview should also be recorded. My lord.
Have you read Preller's remarks?
No, my lord, those are my submissions.
Yeah, fine. No. I want you to,
Yes.
to listen to what Preller said, because you brought this judgment.
Yes, my lord.
This was a 3-bench judgment. Preller was the senior judge, Manamela acting, and Kumalo was the other judge. But this is what Preller said. Manamela was the scribe, and the 2 judges overruled him. I have had the benefit of the judgment of my learned brother, but reluctantly find myself unable to agree with the conclusion to which he has come. The evidence was comprehensively dealt with in the judgment of the court of co, and there is no need to repeat it here. Suffice it to say that there were no misdirections in the judgment, and nor did counsel argue to the contrary. The main problem in this appeal arose from the remarks perhaps inadvertently made by the court of co in its judgment on the admissibility of certain crimes as to his co-accused. It is therefore clear that the court was well aware of the constitutional rights of the 5 accused and the discretionary nature of the exclusionary rule contained in section 35(5) of the Constitution. The subsection reads, evidence obtained in a manner that violates any right in the Bill of Rights must be excluded if the admission of that evidence would render the trial unfair or otherwise detrimental to the administration of justice. The prohibition is against the admission of evidence obtained by a process that violates the constitutional rights of the accused. That means only that if the accused person has, for example, been tortured or assaulted in order to force information from him, that information must be excluded. No finding to that effect was made in the judgment. The rule does not mean that any improper conduct, even if unconnected to the making of the statement, results in the exclusion of the evidence. That would be an application of the controversial rigid exclusionary rule of the North American law. I think it's State versus Ross, that case. The trial court is the primary trial of fact, and this court can only interfere with a finding if we are satisfied that it is wrong. A vague suspicion that all was not kosher and is not enough. Unfortunately, we don't know how exactly what the learned judge had in mind with this remark, but the fact is that he considered every detail of the relevant evidence very carefully and came to the conclusion that the evidence should be admitted. In the process, he expressly rejected the contentions of the appellants that they had been tortured, as well as their evidence that they had made the statement and done the pointing out under the... Somebody interfered with it. Where's the 4th page here? Somebody removed it. Is that page 4? Can I have page 4? Thank you. Yeah. And then paragraph 92 reads, it's page 4.
Yes, ma'am.
One of the main contentions still read page 90. Paragraph 86. 88, sorry. He says, it is not necessary to set out the evidence adduced in the court below as Manamela A.J. has done in some detail in his judgment. My view and position in the matter is informed by the approach advocated by the court in Take and Safe Trading CC versus Standard Bank of South Africa 2004-1 or South Africa SA 597 SCA 2004, where it was stated, a criminal trial is not a game where one side is entitled to claim the benefit of any omission or mistake made by the other side, and the judge's position in a criminal trial is not merely that of an umpire to see that the rules of the games are observed by both sides. A judge is an administrator of justice. He is not merely a figurehead. He has not only to direct and control the proceedings according to recognized rules of procedure, but to see that justice is done. Every person is ensured a right to fair treatment as a suspect and a fair trial as an accused by the Constitution. Section 35 commands that arrest processes and criminal trials be conducted in accordance with the basic principles of justice and fairness. To guarantee the protection, subsection 5 thereof makes provision for the exclusion of evidence that has been procured in a manner that violates any right of the Bill of Rights, if the admission of that evidence would render the trial unfair or otherwise be detrimental to the administration of justice. To ensure a fair trial, a presiding officer or judge may therefore only consider evidence obtained legitimately to establish whether or not an accused is guilty. However, in terms of subsection 5, if the admission of the evidence would not render the trial unfair or detrimental to the administration of justice, even though it might have been in a manner obtained in a manner that violates a Bill of Rights, it will not necessarily be excluded. Therefore, not every violation of a right protected by the Bill of Rights leads to exclusion. See in this regard, as versus Ndlovu and others, 2002, SCA, ZACA 70, 2002, 2 SACR 325 SCA. The section does not couple the discretion to exclude directly to the violation of a right as argued on behalf of the applicant, but to the consequential unfair trial. Therefore, the jurisdictional prerequisites for the exercise of the discretion to exclude is a requirement of unfairness or the prejudice to the administration of justice. What the subsection accords are fundamental and absolute is the right to a fair trial. In S versus Tandwa, 207 SCA 34 RSC 8, Cameron 116 observed the pre-constitutional approach to the exclusion of improperly obtained evidence to be in these terms. The noble feature of the constitutional specific exclusionary provision is that it does not provide for automatic exclusion of unconstitutionally obtained evidence. Evidence must be excluded only if A, it renders the trial unfair, B, otherwise detrimental to the administration of justice. This entails that admitting the impugned evidence could damage the administration of justice in ways that could leave the fairness of the trial intact, but where admitting the evidence renders the trial itself unfair, the administration of justice is always damaged. Differently put, evidence must be excluded in all cases where the admission is detrimental to the administration of justice, excluding the subset of cases where it renders the trial unfair. The provision plainly envisages cases where evidence should be excluded for broad public policy reasons beyond fairness and individual fairness and of the accused. Kachalia in S versus Mtombo said the following: public policy in this context is concerned not only to ensure that the guilty are held accountable, it also is concerned with the propriety of the conduct of investigating and prosecutorial agencies in securing evidence against criminal suspects. It involves considering the nature of the violation and the impact that evidence obtained as a result thereof will have, not only on a particular case, but also on the integrity of the administration of justice in the long term. Public policy, therefore, sets itself firmly against admitting evidence obtained in deliberate or flagrant violation of the Constitution. If, on the other hand, the conduct of the police is reasonable and justifiable, the evidence is less likely to be excluded, even if obtained through an infringement of the Constitution. This accords with what Krichler said in the case of K versus Attorney General of the Transvaal, 1996 Constitutional Court case, where it says sometimes even unconstitutionally obtained evidence, because of the demands of public policy and the demands of fairness in the administration of justice, may be admitted, even if you're aware of the case.
Yes, ma'am.
So this case of Hodis, it's not the be it and the be all.
That's the court cases.
I've quoted you two constitutional cases
That's the
where they say even unconstitutionally obtained evidence. Do you have that? Hello? Key, Attorney General of the Transvaal. Let's read it so that everybody knows it. Right? Do you have it?
Yeah, we're just finding it quickly, my lord.
Yeah, just find it. Yeah, you've got Mr. Computer. So the case has to delve into the intricacies of public policy, the fairness, etc. And this, according to me, this form has got no force of law. Do you agree with it?
As the court cases.
Right, there's no force of law. It's a guideline. But I'm not stopping you from arguing. You can argue that. I'm just saying preliminary. Where's that case?
Oh, my learned friend is finding it.
No, man, just find it. Because people, when they read the Constitution, they all say if the evidence is unconstitutionally acquired, therefore it is not admissible. You better go and examine the phenomena and the exigency under which that evidence has been acquired, the demands of public policy, the demands of fairness, the tension between the demands of the police to maintain law and order and the perceptions of the public regarding the application of fairness. After that, we can conclude whatever cross-examination you
may
want.
other counsels be given opportunity to make submissions?
Yes,
for the
yes,
ruling?
no, everybody,
Thank you, ma'am.
everybody. So Hodes has got a point, but the point is, as I understand the evidence of this witness, predicated on that interview, amongst other interviews, he repaired to Carltonville to go and further investigate. That's what he says, not me. When he got to Carltonville, Ginida came and they went to see the personnel manager, and the personnel manager made a statement to them
My Lord, can other councils respond at this
Yeah.
stage
No, we're
before
going to
the
read this.
ruling is made?
We're going to read this, and then everybody is entitled to
Thank you.
respond.
As the court pleases.
Sorry, Rose, just go and fetch that case. 1996, Attorney General of the Transvaal. Just, I'll check it out. Do you have it in your computer? Yeah, Key. This is K-E-Y. This is Attorney General of the Transvaal, 1996, Constitutional Court, Kirchhoff. You got it? That one. Yeah, that's the one. Sorry. You want it, yeah, I forgot class. My registrar found the law.
Yes, it's paragraph 23 of the judgment.
Yeah, paragraph 23.
It says at times fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Yeah. Go on.
Well, and it says if the evidence to which applicant objects is tendered in criminal proceedings against him, he will be entitled at that stage to raise objections to its admissibility. It will then be for the trial judge to decide whether the circumstances are such that fairness require the evidence to be excluded. It follows that the applicant is not entitled to an order from this court in these proceedings, that the evidence secured as a result of the searches and seizures will be inadmissible in criminal proceedings against him. I don't think the...
Yeah, read that tension. Why critical reasons like that?
Oh, okay.
Because some of us may not know it. He talks about the tension.
There's paragraph 13. Says in any democratic criminal justice system,
Yes,
there is a tension between, on the one hand,
that's it.
the public interest in bringing criminals to book,
Right?
and on the other hand, the equally great public interest in ensuring that justice is manifestly done to all, even though suspected of conduct which would put them beyond the pale. To be sure, a prominent feature of that tension is the universal and unceasing endeavor by international human rights bodies, enlightened legislatures and courts to prevent or curtail excessive zeal by the state agencies in the prevention, investigation, or prosecution of crime. But none of that means sympathy for crime and its perpetrators, nor does it mean a predilection for technical niceties
Stratagems.
and ingenious legal stratagems. What the Constitution demands is that the accused be given a fair trial. Ultimately, as it was held in Ferreira versus Levine, fairness is an issue which has to be decided upon the facts of each case, and the trial judge is the person best placed to take that decision. At times, fairness might require that evidence unconstitutionally obtained be excluded, but there will also be times when fairness will require that evidence, albeit obtained unconstitutionally, nevertheless be admitted.
Okay, yes, Mr. Mnisi. Mr. Gomezon, sorry. Any submissions?
Court, please, my lord. My submission, firstly, I would agree with the principle that each case is decided on its own merits. under the circumstances of this exercise or this discussion is that when we look at the interview that was conducted or was held in the boardroom, it was held under a different pretext from the officer. He was booked out from the police cells to the boardroom under a very wrong case, case 163 of 10/2018. When an interview is carried in terms of a docket that is the accused is now facing on the charges of a case docket under 636. My Lord, the unfair part of the principle in the doctrine of fairness lies on the aspect that if a right was explained to the accused, it was in respect of case number 163 and changing tune when they are in the boardroom. So now the accused is no longer, as per the evidence of there's no evidence before this honorable court that accused was interviewed in terms of the Onongoma case. But all that we know before this honorable court is that an interview was conducted relating to the whereabouts of accused number 2 on the date of the 26th of October 2014. Is that fair for the accused in the cause of administering justice to be taken by surprise to say, this is what we arrested you for, but now we are subjected now to these particular allegations. Please provide us. To what extent did the rights were explained, especially under case number 636? Second fold of my submission is that it's based on the evidence that is before this honorable court that at all material times when the accused number 2 is booked in and out, there's no indication, there's no entry that he was subjected to an investigation under case number 636. So that would tantamount to unfairness, and that will jeopardize to proper functioning of justice system. In this regard, as the facts are as matters are decided on their own merits, it is my humble submission that accused number 2, they should have actually gave him a clinch or an information. He's the one that he received an information earlier that he is involved in the murder case of Senzo Meyiwa. But when he is booked out, when the rights are read in terms of Exhibit LL, they are read under a very wrong case number.
Okay, thanks.
That's my submission.
Yes, Mr. Nisi?
As it is the court.
Yes, no problem.
As it is the court, Madam. Madam, I think there's a bit of a confliction.
Conflation.
A conflation of issues.
Yeah, I mentioned them.
Yes, Madam. When this issue was raised by my colleague Advocate Mshololo, and indicated that there is authority, or in fact, each time the suspect is being interviewed, that interview needs to be recorded. Then my colleague for the state stood up and said, but that's not always the case. Then the court also got in and said, as far as the court understands the process, is that a warning statement is only supposed to be filled in as and when the suspect is being charged for him to be prepared for court. My colleague further insisted that, but that is actually not exactly the case. That is when this commotion or this argument actually started. In order to satisfy himself, then the court invited all parties to bring authority before court to support their submission in respect of what they believe in. The defense, my colleague, Advocate Mshololo, wrote a judgment that specifically addresses the issue that the court said, bring judgment, bring an authority to convince me. We were expecting the state as well to bring a judgment that will go contrary to what the judgment that has been brought by my colleague is saying. The state hasn't.
Okay, fine.
Instead, what is happening now, my lord, we are trying to confuse two issues that are very distinct. Whether or not it is in the interest of justice that evidence that is sometimes unconstitutionally obtained should be obtained or what. But this is not the crux of the investigation as to why we actually had to come here. In the judgment of Hodes SC, it's very clear. The statements regarding with the interview with the suspect is very clear. Each time there's an interview with the suspect, whether or not that suspect is arrested, this document must be filled in with no exceptions. I won't go back and refer to what my colleague has said.
Yeah, I've heard you.
But now there's also a referral to the case of to what the Honorable Judge Prela said. These two cases are totally distinguishable because in the Prela case, my lord, it was not about whether or not each time that a suspect has been interviewed, this document 3M in brackets small letter M must be filled in. It was only a determination on whether or not the statements that were used in those in the decision of this case should be used against the accused person in this case or what. So these two cases are totally distinguishable. As I am standing here, my lord, I am still expecting the state to present to the court an authority that says no, it's still fine for a suspect to be interviewed without having to fill this SAP 3M in bracket M. The state is not
Okay, I've heard
forwarding such information. So basically, we are not saying, my lord, that the court should make a decision and now.
I'm not going to make. Hey, I'm not confused. I'm not going to make a decision now. You're arguing the law. I'm going to make a decision at the end of the case. Don't go about saying, hey, the judge, hey.
That is what I'm trying.
listening to the principle of the law. And the decision which I will make will be predicated in the sense that I gave all of you a chance for the input of the very issue which is being debated in this case. But I'm not making a finding, I'm not making a ruling, never.
Yes, my lord, that is basically would have been my next point.
That I'm going to make a ruling.
And no, I intend to say, my lord, that when my colleague, Advocate Mshololo, raised the issue of the interview with the suspect in the boardroom and whether or not this form was filled, it should be something that should be, my colleague should actually be allowed to proceed with that form of cross-examination. It will then only after all the evidence at the end of it all has been heard.
I said
then
that,
the court
ask your colleague, I said that to her. Didn't I say that to you, Ma'am Mshololo? That I'm not stopping you from going ahead with the strategy of the cross-examination your course on. Didn't I say that?
My lord, the problem is that when after
All I said, do you admit that this form doesn't have statutory application? That's all. And you said no.
My lord,
But I never said to you, stop your cross-examination. Never. I will never say that to any counsel.
My
Never.
lord, after I've been granted that leave, my lord, the state objected.
No,
the
but
state
I decide whether you continue or not Mr. Baloyi. Okay.
The state objected, then the court said we must make submissions.
Yeah.
That's where we are in, my lord.
Yeah, fine.
Thank you.
Yes, Mr. Numalo. Oh, are you still on?
No, I just wanted to wrap up, my lord.
Oh, I said, okay.
Therefore, my lord, it will be very precarious. Actually, it will be a precarious procedure to, at this point, decide this thing as if it is final.
Who's going to decide it? I told you I'm going to decide at the end of the case.
The reason why I'm saying this, my lord, It's because I hear already there are authorities that have been referred to which do not specifically deal pertinently with the issue that the court has raised.
Yeah, in other words, you and Mshololo, Mr. Mshololo and Mamalo and Mr. Mugumezulu, Baloi, at the end of the case, they're still going to have to argue
As it please the court, madam.
about the admissibility of these statements and confession and pointing out how much.
And more particularly with regard to that interview
Yes.
that was held in the
That's
boardroom,
it. You're still
where
going to
this form
argue.
was not fit. Thank you, my lord.
At this
That is
stage-
my submission.
I had two contrasting legal submissions.
Yes.
That's all.
Thank you, madam.
All right. Yes, Mr. Mamaru. Hey, my God.
Why you be shy, son, madam?
And I may just add, other judges just keep quiet. They keep quiet and then yes sir, yes sir, yes sir, and thereafter they come with a decision.
As it please-
I don't do that.
As it please the court. Yes, that's
I don't do that.
Court should not only be a passive umpire.
Yes,
as it
yes.
please the court.
Yes, Mr. Mumal.
My lord, my starting point will be that it is not enough for the police to use the SAP 14A, because we've been hearing that the SAP 14A was used, that is before and after the accused, that is accused number 2, was at the boardroom.
That's a guideline.
Yeah, as a guideline. I'll re-emphasize and follow the decision of Holtz SC to the effect that whenever the interview is conducted with the suspect, it must be recorded. And the statement regarding interview with suspect form must be used. I'm having the understanding, my lord, that if that is not followed, then it violates the accused rights in terms of Section 35 of the Constitution, and therefore, in terms of Section 35(5) of the Constitution, it stipulates that evidence obtained in violation of the accused rights must be excluded if that, or the admission of that evidence will render the administration of justice into disrepute. This form gives an obligation. It's an obligation to the police to say whenever the interview is conducted with suspect, this form must be used.
Yeah, I agree with you. You see, it's incumbent upon you as advocates of this court to make representations to the Minister of Justice, to pass regulations
Yes.
addressing the very exigence.
Yes.
Manje antet niyakhuluma nje.
It looks like there will be a number of representations.
Yes, you have a right
Yes.
as that's how the law develops.
Yes.
When there's a lacuna in the law,
Yes.
the persons who practice in this court must take it upon themselves to address that lacuna so that the Minister of Justice, Lamula,
Yes.
must address that.
Yes.
Because it's going to recur. That's why you have 9 provinces and you get 9 different decisions in all the 9 provinces. Okay.
Yes. Thank you, madam. Thank you.
Mr. Mshololo, you are continuing.
No.
You are continuing with your cross-examination.
No, my lord, we're still waiting for this.
No, you are continuing with your cross-examination. Is that not so?
Yes.
Yeah, now we listen to Ubaloi. Remember I said I'm not deciding the issue now. I'm going to listen and hear all of you, what you say. So Baloi must say whatever he wants to say. Thereafter you continue with your
Yes,
cross-examination.
as the
Okay.
court business, my lord.
Is it so difficult, madam?
As the court business, my lord.
Yeah. Yes, Mr. Baloi.
Mr. Court, please, my lord, we just want to come from a slightly different angle, and we raise an objection based on purely issue of evidence, of relevance. You know, my lord, we objected on the basis that the questioning is not relevant in the sense that my learned friend was pursuing a line of questioning that says the accused number 2 made a statement. From the evidence that has been given by the witness, I'm not even sure if one can put it as high as that to say that the accused made a statement. What we have before court, my lord, is
He made a denial.
Yes, it's evidenced by Sergeant Mohani that says we convened in the boardroom with the accused. I warned him according to his rights, and as a suspect, I informed him what the purpose of the interview was, and the accused gave an explanation. I don't know if one can say that it's a statement. He gives an explanation. He says he doesn't even tell him about the date on which the offense was committed. He says, I'm investigating the case of the death of Mr. Senzo Meyiwa. And the accused then, out of his own volition, says, well, I know about that matter. I read about it in the newspaper. Is that a statement? We submit with the greatest of respect, my lord, that if one looks at the form that my learned friend wishes to use to cross-examine this witness, it refers to some sort of a formal statement. All that Sergeant Mukhan was doing was to offer the accused number 2 the opportunity of an explanation, and he says, I was at work, and that defense is pursued. Suppose, my lord, for one moment, that if the explanation that the accused gave, that he was at work, if the cloaking records confirmed his version, that would have been the end of the matter. There would have been no need to pursue the matter any further. It could have never been the intention, and even with the judgment that my learned friend has referred to, that where an accused gives an explanation, that the formal process that my learned friend wants to embark upon, that should be followed. These are just preliminary issues that are aimed at establishing whether a formal statement or a statement should be obtained from the accused at a later stage, and which happened in this case, my lord, is after these preliminary processes, a formal statement was obtained, to which the investigating officer will refer to when he testifies. It can never be in the intention of the judgment by then Judge Waters to say that in every instance where there's that preliminary inquiry, that this formal process should be embarked upon, that a form should be completed, and the form speaks for itself. It talks about a warning statement. It talks about the involvement of the prosecutor, the station commissioner. We submit with the greatest respect it envisages a process where a formal statement is intended to be taken from an accused. And if one looks at the discussion under this topic, it all results under section 217, which deals with the confession. So we submit, my lord, that the intention here with this form and with the process that my learned friends wants to embark upon is if, or in the case where a statement of some sort has been made. We also want to refer to the judge's rules, my lord. We know that they have, as it were, been taken over or subsumed by the Constitution, but these rules still serve as a guide.
What is that, 1946?
Yes.
1940,
and 1931.
41, when
Yes,
I was on the
they were approved at a conference in Cape Town in 1931.
Yeah.
And the writer Himstra describes the purpose as follows. He says, these rules are administrative directives for the guidance of the police force. And he says, the judge's rules are mainly of historical interest because they are longer in effect, their role having to a large extent been taken over by the norms in the Constitution. the following is important. They nevertheless remain general guidelines for the police and the courts for the everyday conduct of police officers in respect of suspects. And in this instance, we want to refer to Rule 5, which says, where a person in custody wishes to volunteer a statement, he should be allowed to make it, but he should first be cautioned. And this is contained in Section 35, which distinguishes between an arrested person and a detained person. And Section 35 states that the person in detention and custody should be informed of the right to remain silent, to be informed promptly of the right to remain silent, and of the consequences of not remaining silent, and not to be compelled to make any confession or admission that could be used in evidence against that person. So if one looks, once again, my Lord, this buttresses the point that we are of the view that in this instance, one cannot really say that the accused made a statement, because if one looks at subparagraph C, says not to be compelled to make any confession or admission that could be used as evidence against that person. And the same is reiterated in Section 35(2) pertaining to a detained person. And in this instance, a detained person also includes a suspect who's in custody, as it was held in the Sibajan case. But to come back to the judge's rule, rule number 8 says the caution to be administered to a person, in other words, that he's got a right to not to make a statement and what the consequences thereof is or are, says the caution to be administered to a person in custody should be to the following effect. And the rules distinguish between a person who's formally charged and a person who's not formally charged. In the case where a person is formally charged, it says, do you wish to say anything in answer to the charge? You are not obliged to do so, but whatever you say will be taken down in writing and may be used in evidence. And we submit, my Lord, that this is what this form caters for. And paragraph B says, where a prisoner volunteers a statement otherwise than on a formal charge. In other words, in this instance that we're busy with, if the accused volunteered a statement, and here the judge's rule refers to a statement, where a prisoner volunteers a statement otherwise than on a formal charge, the warning that should be administered should be to the following effect. Before you say anything, I must tell you that you are not obliged to do so, but whatever you say will be taken down in writing and may be given in evidence. We submit, my Lord, that what we are currently seized with, it's not a statement, it's just a mere explanation, an alibi that the accused gave that he was at work on the particular day, which was subsequently followed. And we submit, therefore, my Lord, that this form that my learned friend wishes to make use of is irrelevant.